online lectures organized by Department of Law, Central University of Kerala. We are extremely honored to have with us Dr. Saji Shivan, is an associate professor at the School of Law, Vellore University of Technology, Chennai. Dr. Saji has over 15 years of experience in teaching, research, and legal practice across various fields of law. He has been awarded the Dr. B.R. Ambedkar LLB Award, secured first class in LLM, and earned his PhD from the University of Kerala. His specialization in human rights law, constitutional law, family law, environmental law, and cyber law, and has served in prestigious legal institutions and universities across Kerala, Mumbai, and Chennai. Dr. Saji has presented numerous academic papers in national and international seminars, published more than 50 high-quality academic articles, edited books, and currently served as an editor and reviewer for several renowned journals. Today, he will be sharing his insights of the topic constitutional principle of vicarious liability of state fundamental rights violations. Sir, I would like to welcome you, and you may continue the session. Thank you, sir, and welcome you.
Thank you. Thank you for the warm welcome. First of all, I extend my sincere gratitude to Department of Law, Central University, Karnataka, for giving this wonderful opportunity to deliver some thoughts related to constitutional principles related to vicarious liability on fundamental rights violations. So, kindly enable to share my screen. I want to share my PPT. Okay. Is my PPT sir visible?
Sir, it was visible, but now it is not.
Okay, sir. One second. One second.
Yes, now it is visible, sir. Your screen is visible.
Okay, sir. Okay, sir. I will open my PPT. No.
Yes, it is visible.
Yes, it is visible. Okay. Now it is visible.
No, sir, you cannot move out of the screen. If you are showing the PPT, it should be open in your desktop, sir.
Okay.
Your screen is visible, but your interface, Google Meet interface is coming.
Okay, then I make it.
Now it is visible, sir. Now don't move, sir. You will have to control from like this. Yeah.
Okay, sir. Okay, thank you. Now it's clearly visible, sir.
Yes, sir.
Okay, thank you. Thank you for this wonderful opportunity. Now I am moving to the topic, the constitutional principles on vicarious liability of states for fundamental rights. So here we are going to discuss two aspects. First of all, the tortious liability of state and when state is vicariously liable. Second aspect is the liability of state for fundamental rights violations. What extent the state is bound to provide compensation for fundamental right violations done by its officials. So first I move to the first part, the tortious liability of state. So what is tortious liability and how the principle came into India? So, as we know, the tortious liability of state, particularly in India, it's a complex issue. Why it is complex? Because we don't have any particular law with related to this tortious liability. Then how we are providing compensation, or then how we are providing justice to the people when the state violate their rights? It's only through two aspects. First of all, by the interpretation of judiciary, and secondly, some constitutional provisions which directly or indirectly states the individuals can claim compensation for tortious acts done by the state. And what exactly the tortious liability? So here, when we discuss about tortious liability of state, it is the legal responsibility of the state. What legal responsibility? The legal responsibility of the state for any damage or harm caused by a person's or their property because of their wrongful act or omission. So how we can know the act or omission of the state is violate the rights of people, and who is responsible for those violations, and what omission or act constitute as a damage or harm to a person. So here this accountability of state for the wrongful activities of its servants. So here the word state means it's represented by its servants. So during the tenure of job, if they do any act which involve any harm or damage to a person, the state is vicariously liable for those acts. So this liability fixed through some legal maxims, which we have studied under law of torts. Q facet perilium facet per se, as well as the respondent superior, res ipsa liquitor. These are the maxim which leads the way to the state for the vicarious liability or the tortious liability of its servants act when it is harmful to the public. And here the idea of tortious liability of state creates through these principles. The principle of Q facet perilium facet per se, res ipsa liquitor, and the res ipsa liquitor. So here, the state is responsible for the wrongful act of its servants. So whenever a servant or a representative of the state done any act through which any person who suffer any damage or harm, the state is bound to compensate, because we know the tort is a civil wrong. For that only we can claim damages in the way of compensation. That's the principle laid under tortious law. So, with related to state's tortious liability, from the public fund, the state compensating the victims who are subjected to damage or harm due to the act of the servants of state. Now we can see from where the concept of tortious liability of state came into act. Because we are not discussing about tortious liability, which we well aware under tortious law. But when it is about to state, from where we have this concept, always we have the backup of common law principles, because most of our laws we have adopted from common law countries, US, UK, France, Germany. So this principle also developed from the common law country, where the principle is that king can do no wrong, because the state is immune from any act done by the king. Whatever done by the king, it is justified, because the concept that king can do no wrong. But it was changed. We can see later how the principle was changed. And from that principle, which carried in India during the colonial period, because we know we are the colonies of Britishers. So whatever developments made in Britain, automatically we adopt and accept in our country. So similarly, the Government of India Act, under which the provisions allowed suit against the Secretary of State. In those times, the Secretary of State is considered as the highest official of the state or the representative of state. For any act done by the state where we can sue against the Secretary of State. With the powers, some concept were again remained under the sovereign functions, because we have they have classified the functions of state into two: sovereign and non-sovereign. So while we considering the historical development of the tortious liability of state or the vicarious liability of state, it developed from English law, and it flows from the British rule, particularly the Government of India Act. When we become independent, we have included the same principle under Article 300. So don't misunderstood that Article 300 directly allow the states for tortious or vicarious liability. But the principle underlined under the Constitution give a provision through which we can sue the state for its wrong. So Article 300 particularly states for can sue and can be sued, either the union or the states. We can sue the state or the union for any act, either it's a wrongful act or for any other remedy where we can sue the state. So Article 300 is not only limited to tortious liability, when it is contractual liability, or when it is related to trade and business, or any action we required against the state, where Article 300 allow to sue against the union and the states. So from Article 300, the key development of tortious liability arises. So where we distinguish when we are suing for tortious liability, the court look into it whether the state perform a sovereign function or a non-sovereign function to proceed with the suit. So when it is a sovereign function, the state is immune. State is immune means the state is free from all liabilities. When it is non-sovereign function, the state is liable for whatever their officials done and the harm happened to the public. And as we have seen, the principle developed from common law, where the concept is that king can do no wrong. Whether still it is remain or whether there are any changes, and if it is, how the concept were changed, and the state, even the common law countries were now liable for this tortious act, or the state is vicariously liable for the wrong done by the officials of state. So here we can see the development of tortious liability or vicarious liability of state. How the king can do no wrong become king can do wrong. So it's developed through the Crown Proceedings Act of 1947, which gave authority to the public. They can sue the government like a private individual. So the Crown Proceedings Act provide provisions for suing the state for any wrongful act, similar to the private individuals. Again, in United States, they have Federal Tort Claims Act 1946. In France, they have developed their administrative law to strengthen the state's liability for wrongful act done by its officials. While in India, we have no specific legislation, as I have said, we find the place under Article 300, but it is not a direct provisions where we can claim tortious liability. Through judicial interpretation, we have established Article 300. So, if you want to know what exactly is the tortious liability of the state, we need to understand what are the functions done by the state. Because we have seen that state is bound liable only when the state doing some function, and with the within that function, if any person suffer any damage or harm, then they can claim compensation. So we can see what are the functions of state. And the functions of state were classified into two: sovereign and non-sovereign functions. Sovereign function means where they can do any act or the core governmental duties. When they done the core governmental duties, if any damages or injuries happen to any individual or the public, the state is not liable. For example, defense. During military act, if any person's life is lost, they cannot claim any damages. But when at the same time, when a military action without any caution, there they can take actions in lawmaking, means of law and order, administration of justice. These are considered as the sovereign functions of the act where they cannot claim damages. And second one is non-sovereign functions, which is allied with the sovereign functions, because both the functions are done by the state or the representative of the state. And one is considered as the public function, another is considered as the private functions of the state, where the officials are included in both the functions. For example, the defense is part of sovereign functions, but supplying materials or transiting material to one place to another place for any defense purpose is not considered as sovereign function. It is a non-sovereign function. For example, some militants uh, they went for leave and they came back to the their respective appointed places where they are using military trucks. It is not a sovereign function. They are defense persons, but the purpose is not sovereign in nature. So how we can distinguish this sovereignty, the sovereign functions, the doctrine of sovereignty? So we identify the concept of doctrine of sovereignty on the basis of two principles. First one, how it was developed, the foundational basis from where the principle was developed. Secondly, what is the constitutional mandate? How the Indian Constitution protects the right of the state, or the state is protected from immunity. So first we can see the foundational base. So foundational base we have seen when we have discussed the historical aspects, the rex non protest peccari. The king can do no wrong. So king is supreme. So whatever said or done by the king is supreme. So no one can question the act of king. That is the foundational basis of the sovereign immunity, where the individual cannot sue the state in courts without the state's consent. If they want to sue, then they need to get a consent from the state. Only after getting the consent, they can sue for the tortious act. And what is the principle behind this sovereign immunity? Why they are enjoying this sovereign immunity? This is a justification. The justification for the wrong committed by the state or its representatives. So the common law protects the state as well as its representatives when they are doing some wrong, which is for the benefit of the state. In those cases, the state is protected through sovereign immunity. And now we can see whether this foundational base is applicable in India, because we are in our India. So we need to discuss whether we follow the common law principles. We have adopted the common law principle in our law, but whether the same principle is following under our administration of justice. No, because the doctrine is not accepted by the judiciary. The judiciary said it is an outmoded and obsolete provision through which the state is immune from its wrongful act. So where it was said, because we are saying it is said by judiciary. So it was clearly said in the case of state of Andhra Pradesh versus Challa Ramakrishna Reddy. In this case, the apex court clearly indicated that the distinction between sovereign and non-sovereign functions and the relevance of the maxim king can do no wrong. So the court clearly stated that in Indian jurisprudence, the king can do no, there is no place for it. So we accept the principle, but the courts never recognize it as a base for granting or fixing vicarious liability of the state. So this is the foundational basis. What is the crux? Now we can see the constitutional mandate. How India preserve the concept of vicarious liability or tortious liability. Because we have seen there is no specific law or legislation which are addressing the accountability of state for committed by its torts committed by its representatives. So there is no specific legislation or law which states that we can sue the state for any tortious act. But we found the place from Article 300. And from where we have found this principle under Article 300? Because it's from the dominion of India. The corresponding provinces or the corresponding states in India might have sued or be sued if constitution had not been enacted, because the provisions are already there in Government of India Act. The same principle we have adopted under 300 through interpretation. So if we need to get more closer to the interpretation, we can refer the Government of India Act 1915, 1935, and the prior to the East India Company Act 1958. Because all these statutes provide a necessary link between the sovereign and non-sovereign functions of the state. So we have seen the foundational base as well as the constitutional mandate. In both the places, we haven't seen any concrete principles related to tortious liability. So only we can draw a line between the sovereign and non-sovereign functions through the distinction we are fixing tortious liability or the vicarious liability of the state. Now we can see what is the difference between the dichotomy of sovereign and non-sovereign. So what is sovereign and non-sovereign functions were distinguished in the very famous case, the Peninsular and Oriental Steam Navigation Company versus Secretary of State for India in 1861. From there, we have a clear cut distinction between sovereign and non sovereign functions. What functions are sovereign and what functions are not sovereign were laid under Peninsular and Oriental Steam Navigation Company. So here, the court observed that the state is vicariously liable because the functions were non-sovereign in nature. So, if the act is not sovereign, then action could be lie against the state. From there, we can see a series of judgments where the judiciary clarified the sovereign and non-sovereign function, and they have admitted that the state is liable for the tortious act done by its servant. So we can see some landmark judgments related to tortious liability of state. First one is state of Rajasthan versus Vidyavati. So whoever studied law of torts, they are very well about what happened in the state of Rajasthan versus Vidyavati. So where a driver were used his collector's vehicle, and when he went to take the collector from his home, on the way, one person asked for a lift, and the driver gave the lift. But on the way, the vehicle met with an accident, and the person who lost his life. So his widow filed a case against the state for compensation. So here, the court observed that the sovereign immunity had become an outmoded and should be discarded, emphasizing India's modern role as a socialist state. So there, they have said that It's a non-sovereign function. The calling the collector from his home to office when the driver went to the on the way to the collector's home is not a sovereign function. It is a non-sovereign function. And second one is the Kasturi Lal Ralia Ram Jain versus State of UP. It is a cardinal case. Still now the case is not overruled. So it clearly states about what is sovereign function. Because while we are analyzing the facts, we might think that the case, in this case, the person must get compensated. But the court interpreted in a different manner where the state is protected from providing compensation because the state draw that the duty done by the officer is a sovereign function. And here, the interesting thing is uh, the police officer they have seized some gold from a person and they kept in the strong room, and the constable was in charge of that strong room. So after acquittal, the person claimed back the gold which seized from him. So while proceeding the process, they have found that the constable who is in charge of the strong room who took the gold and went to Pakistan. So, what was the interpretation made by the court in this Kasturilal Ramjeen case? And how they have stated that the state is not liable to provide compensation? Because the first step that the police who arrested and seized the gold was a sovereign function. The second part, the constable who stole the property and went to Pakistan, it is not during the act of his employment. It is his personal. So here, sovereign means when an officer doing something on behalf of the state. But here, what the constable done? He done something as personal personal. So why in Kasturilal the court state that the state is immune from that act. And again in Satyavati Devi versus Union of India, so some hockey players were taken from airport to the playground in an Air Force vehicle. During the transit, they met with an accident. So this is also not considered as a sovereign function. So there are many examples. Union of India versus Jaso, Union of India versus Savita Sharma, and Nagendra versus Rao and Company versus State of Andhra Pradesh, where the court clearly made a distinction between sovereign and non-sovereign function. So in Kasturilal and Nagendra Rao was a great example of sovereign functions because in Nagendra Rao case also it stated it is a sovereign function where the state is not bound to provide compensation. And now we can move to the second part. As we have seen, we are divided into two, the tortious liability of state and secondly, the liability for fundamental rights violations. So now we can see how what's the principles we are following to provide compensation for fundamental rights violations. Because we have seen in everywhere the state Due to the act of state, some persons they are losing their life. Sometimes they are behind the fetter or they are unlawfully detained. So what's the remedy for those acts? Because we know the fundamental rights we can only claim against the state. One second, Jayendra sir. Okay. Uh, so now we can move to the liability for fundamental rights violations. The vicarious liability of states for fundamental rights violations. So there are two questions. First of all, whether it is a normal tort. Secondly, what extent the state is liable for fundamental rights violations. That means whether state is vicariously liable, whether state can protect it under its sovereign immunity when it is related to fundamental rights. Here, the fundamental rights mean it is not in generalia. It's, it is specific. Only some kind of fundamental rights alone protected under the vicarious liability of state, not all fundamental rights. Particularly the right to life and personal liberty under Article 21. Because we cannot claim any right under Article 19. Suppose our right to speech and expressions were curtailed by the state, we cannot claim compensation. We have seen during Jammu and Kashmir issues in Goa, we have seen when the whole networks were disconnected by the state, where we cannot claim it as a right, as well as even if it is a right, we cannot claim compensation for the loss suffered during those acts. So, but when it is right to life and personal liberty, the state is liable for the acts done by its officials, where we can directly move to the Supreme Court and High Court under Article 32 as well as 226, where we can file writ petition as well as we court can grant monetary compensations. So the vicarious liability of the state for the fundamental right violation, it's an absolute liability. In some cases, the court clarified that the state cannot claim sovereign immunity when it is involved the right to life and personal liberty of a person. So, how the principles were established? How the liability for fundamental rights were developed and implemented by the courts? So, here the court followed the strict sovereign immunity approach inherited from British law, because the state always tried to expand the scope of state liability and provide compensation for the victims in fundamental rights cases. Is any doubt? Because I am not able to see the message box.
No, sir,
Hello,
no
sir. Am I
doubts.
audible?
Yes, sir.
No, sir. It is, I think, by mistake somebody has unmuted, sir.
Okay, we can continue. So here, how the courts fixing the liability over the state for fundamental rights violations. So they follow the strict liability. the state is liable for the act done by its official, whether it is sovereign or on a non-sovereign functions. If it is a fundamental right violation, the state is liable. So from there, they have started to develop the concept of constitutional tort. So once the principle of constitutional tort developed, the compensation were granted for the violation of fundamental rights under Article 21, and which we can claim through Article 32 and 226. So why the courts move from the concept of sovereign immunity? Because the role of court is to provide administration of justice. While providing administration of justice between the state and individual, they always maintain a balance where both the parties not suffer. But when it is fundamental rights violations, why the court move from the principle of sovereign immunity? Because of to provide accountability, especially in the case of custodial violence, negligence, and human rights violations. We have many examples: the custodial deaths, custodial torture, fake encounters by the militants, and negligence on the part of the officials. When some poor person they are approaching officials, purposefully they are not providing some grants which are essential for the existence of their life and livelihood. So these are some reasons why the court moved from the concept of immunity, and they make the state liable for fundamental rights violation. So through this interpretation, the court narrowed the concept of sovereign immunity with a greater focus on justice for citizens. Because when the state is act as an autocrat where the citizens are losing their life, where judiciary cannot sit as an idol. That's why they have moved from the concept of sovereign immunity, and they have make it as a strict principles. And what are the principles which they have adopted and fulfilled to provide compensation for fundamental rights violations? There are some key principles governing this public law remedy. So, when the state violates the fundamental rights of a person, particularly Article 21, right to life and personal liberty, where we can claim compensation. When the person is claiming compensation, the state cannot claim sovereign immunity because the court clarified that the concept of sovereign immunity is non-applicable in the case of fundamental rights violations. And secondly, the strict and absolute liability. When any act in contravention of fundamental rights where the court follow the principle of strict and absolute liability in providing compensation for the victims. And the third principle is the vicarious liability, because whatever act done by its official, the state is vicariously liable for those acts. So the state always bound to provide compensation even though the unlawful act may have been committed by an individual employee. So why in some cases, custodial death cases, even the police officer not in duty, but when he involved in the custodial torture, the state is bound to provide compensation. So there are many examples where we have seen the officers who are not in duty but they are involved in the act where they were directed to provide compensation. So the judicial approach is widened in case of fundamental rights violations. We can see a plethora of cases where the judiciary expand the horizon of vicarious liability of the state and granted compensation to the victims in different cases. We can see some fundamental cases where the court granted compensation for fundamental right violations. Most of the legal fraternities know about Rudol Shah versus State of Bihar. So a person, an innocent person, a person who was arrested and after trial he was acquitted, but due to some mistake he were imprisoned for 14 years. So after 14 years only, it came to know he was acquittal a very long back. So here, hello.
Yeah, sir.
Ah, yeah, I thought that I have logged. So in Rudul Shah, we know. So here, after 14 years, it was found that the persons were acquitted very long back. So the court granted 30,000 as damages for unlawfully keeping a person inside jail after being acquitted. And the second one is Sebastian M versus Hongre versus Union of India, the custodial disappearance. So when a habeas corpus petition were filed by the wives of the missing persons, where the authorities were failed to produce the person. Here, the compensation granted only on the condition that the failure is happened on the part of officials. They're unable to find the person. So why the missing persons wife were granted 1 lakh compensation. And another decision is made in Beam Singh versus State of Jammu and Kashmir, unlawful arrest and detention of an MLA, and he is restrained from participating in assembly. So where the court awarded 50,000 as compensation because participating of an MLA in assembly is his fundamental rights. It's part of his right to life and personal liberty. So here it is stated that the compensation made as a remedy for the illegal confinement of that MLA. And in Nilabadi Behra, the custodial torture by the police. So here, the court explicitly ruled that the sovereign immunity is inapplicable to compensation for Article 21 violations. The custodial death is a heinous act done by the on the part of police officers. And Seheli versus Commission of Police, the custody of death of a 9-year-old child due to beating. So, in an investigation, the child accompanied with the parents. But in the interrogation, the child were beaten and she died. So the court granted 75,000 as compensation. And in Nambinarayanan versus State of Kerala, it's a very famous case related to uh, India because three scientists were charged against some conspiracy and they were wrongfully detained. So he was imprisoned for life. After releasing his life imprisonment, he moved a writ petition to the Supreme Court stating that his detention was illegal. he was not properly his case was not properly investigated, and the evidences were fabricated, and he succeeded to prove that he was illegally detained. So the state were asked to provide 15 lakhs as compensation. So here again reaffirming the state's vicarious liability when the person's fundamental rights are violated, or right to life and personal liberty is violated, where the judiciary has to provide compensation for those persons. And the latest case, the Said Masar Ali versus state of Madhya Pradesh. So in this case also, that means the present scenario also, the court have the same concept from 19 1864 to 2025. The court have the same concept in tortious liability, particularly in fundamental rights violations. So here, the Madhya Pradesh High Court observed that the principle of sovereign immunity does not absolve the state from liability when a citizen suffered damage due to police officers' actions. So it is only a limited number of cases. We know there are a large number of cases where the state is asked to provide compensation for fundamental rights violation. Most compensations were claimed against the police officers as well as militant actions. So we have seen the principle and the judicial approach and how they are providing compensation to the state. Because whenever there is a right, there is a remedy. Similarly, whenever there is a principle, there are some difficulties in establishing those principles. Because from the beginning, we have seen there is no particular legislations. Only through interpretation, we are using a constitutional provision. So there are some challenges in establishing vicarious liability of the states. So, what are the challenges faced by the judiciary in establishing the vicarious liability of states? First of all, it is related to the defining of sovereign functions. So, many times we cannot separate some function as sovereign and non-sovereign because of some involvement of sovereign functions. Some functions may consider as non-sovereign in nature, or vice versa. So here, when a case came before the court where the court struggled to identify or distinguish between the sovereign and non-sovereign function. And second challenge is to there is no uniform law. Because in some cases, the judicial interpretation through the judicial interpretation where compensations are granted, but the similar cases the judiciary deny the compensation. Because we have seen the Kasturi Lal still is a non-overruled judgment. But when we think in the view of a common man, where we can say that the compensation must be provided because it is done by an official. And the third challenge is the increasing state involvement in welfare and commercial activities. So when the state is a welfare state where the functions are more concrete and concentrated, where sometimes the state as well as the judiciary cannot justify some acts, but at the same time they are unable to provide compensations. Special economic zones we have seen because they are governing with special laws. If any violations happen, many legislations are not applicable in special economic zones. So there we are facing issues in sovereign and non-sovereign functions. Another challenge is delay in compensation. The courts are granting compensation, but the state they're filing appeal. So the victims are not compensated on time. Another aspect is the balancing immunity and accountability. The courts must protect essential state function while ensuring justice for citizens. That means some functions where the court cannot interfere and provide compensations. So these are the challenges faced by the states. Now we can move to the what are the current judicial trends, because we have seen in 2025 case where the court observed that non-sovereign cannot be used as a tool to escape from liability. So the modern trend is the court try to make government more accountable for tortious acts committed by its employees. And again, Article 300, it's lack the clarity regarding a scope of state's immunity. What what are the subjects in which the state can claim immunity? And again, the court always try to overcome this concept of sovereign immunity. And in case of fundamental rights violations, the judiciary, through public law remedies, has created a robust compensatory jurisprudence, the constitutional torts. So it is developed by the judiciary as a modern principles. Through that principles, they are granting compensation to the victims. So the concept of king can do no wrong never been applied in India. Still, the same condition the judiciary follow in tortious liability. So the general principle is that whenever the state done any non-sovereign functions or exercising any non-sovereign powers, the state is liable for those tortious acts. And again, the distinction between sovereign and non-sovereign activities is vague and has lost relevance in modern times due to the state's role as a welfare state. So in welfare state, sovereign functions are lesser than the welfare act of the state, or some welfare acts itself is a non-sovereign function where the court cannot grant compensations. Even if the state done any tortious act or done any violations or omissions where the judiciary is fettered to provide compensation. These are the current trend of judiciary related to vicarious liability of state for fundamental rights violations. So these are some aspects which we can grab as a crux of what exactly the vicarious liability of state for fundamental rights violation. Now I am moving to the my conclusion. The constitutional tort and ensure compensation for violation of fundamental rights. So why we have developed the constitutional tort? Because the constitutional tort is to ensure compensation for violation of fundamental rights where the person's life and liberty should be protected and maintained. And the court always play a key role in balancing state immunity and citizens' right. So here Now, the judiciary give more emphasis on citizens' right than the state immunity in relation to fundamental rights case. So we need a comprehensive legislation to clarify, define, and scope and limits of state liability. So until and unless there is a clear-cut definition of a particular principle, we cannot make it as a strict one. So that's what the judiciary pursue from the state liability over tortious act. Thank you for your patient listening. If you have any doubts, you can ask.
Okay. Thank you, sir, for that insightful and thoughtful provoking session. Your perspective on the constitutional principles regarding vicarious liability of the state for fundamental rights violations were truly enlightenment. I would like to thank you once again and thank to all participants. Thank you, sir.
Thank you. Thank you for